what the case law says not to do, which is parse out the separate conduct. In count 4, I'm sorry, parse out separate potential consequences. In count 4.
Good morning, Judge. Before you is case number 21 CR 614, captioned State of Ohio versus William Beasley. Your Honor, we were last before the court on March 3rd of 2022. Prior to that, a jury trial had commenced on February 22nd of 2022 and culminated on March 3rd of 2022, at which point the jury reached a verdict of guilt as to count 1, felony murder, count 3, involuntary manslaughter, count 4, endangering children, a felony of the 2nd degree, count 5, endangering children, a felony of the 3rd degree. On both those counts, they made the additional findings. At the time of the verdict, Judge, you ordered a pre-sentence investigation of victim impact statements and the victim impact statement. Those reports have been completed and submitted for court review. The defendant is present today in court with counsel, Ms. Blake and Ms. Tuttle. He has 26 days to his credit. We are here for sentence, Your Honor.
Before we get to the sentencing hearing, there's the, I'm going to inform Mr. Beasley of his duties to enroll as a violent offender under 2903.41. So, Mr. Beasley, I'm going to read this form to you, ask you to acknowledge that I read it to you by your signature. The county of conviction is Lake, case 21, CR 614, conviction under 2903.02B. Last name Beasley, first name William. Expected residence address 82 Wicklow in Eastlake. Paragraph 1, you've been convicted of or pleaded guilty to a qualifying violent offender offense as defined in 2903.41. You are required to enroll in person with the sheriff of the county in which you establish residency within 10 days of coming into that county, or if occupying a dwelling for more than 3 days in the county. You are required to provide to the sheriff certain information, including your social security number, full name, and any alias you use, your residence address, information regarding the offense for which you were convicted of or convicted or pleaded guilty, a description of any scars, tattoos, or other distinguishing marks on your person, the name and address of any place you are employed or attend school, any driver's license number or commercial driver's license number or state identification card number issued to you, the license plate number of each vehicle owned or operated by you or registered in your name. The vehicle identification number and a description of the vehicle must also be provided to the sheriff. You are required to provide the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of your enrollment. After the date of initial enrollment, you are required to re-enroll annually. You must update and or amend any of the information described above that is changed and provided any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar day on which you were initially enrolled. If you change your residence address, you shall provide written notice of that change to the sheriff with whom you most recently enrolled and to the sheriff in the county in which you intend to reside. You are required to comply with all of the above described requirements for a period of 10 years unless your sentencing court determines otherwise. Since your expected residence address is located in Lake County, you shall enroll in person no later than 10 days after release with that county sheriff located at 104 East Erie Street, Painesville, Ohio. Failure to enroll or failure to verify residence at the specified times will result in a criminal prosecution. And the last paragraph says you acknowledge the above requirements have been explained to you and that you understand the requirements and you must abide by all the provisions of the ORC, sections 2903.41 through .44. Ms. Tuttle?
Your Honor, for the purposes of the record, we would lodge an objection to the constitutionality of the registry for the purposes of appellate counsel. However, we're comfortable proceeding with his signature today.
Okay, thank you.
Sign right there, and it's back to you. Right there. May I approach and return the form?
All right. Before we start, let's address the issue of merger. Ms. Naroda, do you want to start?
Judge, it's the state's position with respect to proceeding to sentence today that the state would elect to proceed on counts 1, that being felony murder, and count 4, F2, endangering children. It's the state's position that count 1, felony murder, and count 3, involuntary manslaughter merge. Counts 4 and counts 5, endangering children, merge, as they come from the same code section. However, it's the state's position that count 1 and count 4 do not merge. They're separate import, and they're separate offenses. The court heard the testimony. Zachary suffered multiple injuries. The lethal injuries were the brain injuries, and he suffered significant skeletal injury. And it's the state's position that each of those counts address separate injury, and those injuries were inflicted at different times. So the state would request to proceed with counts 1 and 4 separate, apart, standing on their own.
Ms. Blake?
Your Honor, with respect to merger, what we would point out is that it's our position that all counts merge, and it appears that the state's proceeding on their argument based on separate harm. And in this case, what we cannot get around is that the cause of death was complications of blunt force injury to head, trunk, extremities, with skeletal and brain injuries. We keep coming back to that. So I don't think we can separate any harm from the death in this case, and we did file a brief kind of detailing that. I'm happy to answer any questions that the court may have.
So the predicate for count 1 is the endangering children, F2, correct?
That's correct, Judge.
And that's in count 4.
Our position has been that count 4 was a standalone count based on the skeletal injuries. The state did not charge the predicate offense of endangering children that gave rise to the brain injuries.
Your Honor, our position, we've had a lot of conversations with the state about this, is that that's not clear from the indictment. And in fact, the way the jury verdict reads, it certainly reads, and again, taking into account the jury's question in this case, it certainly appears as though the jury felt that the non-lethal offenses were the predicate offenses for the death counts in this case. We keep coming back to, if the state didn't charge the predicate, the state has the burden to prove that separate conduct, separate motive, or separate harm throughout the course of the trial. The state has to show that by evidence. The only point in time in which the state in this case tried to differentiate anything was in closing argument. In closing argument, the state stood up and said, count 1 is for this, count 2 is for this, count 3 is for this. And that is the first time we heard that. Even in the state's multiple bills of particulars, the state did not separate the cause of death. The state did try to separate separate injuries for the, again, I will just call them the non-death counts in this case. However, the state could not separate that their cause of death ties all of those things together. And as the case law contemplates on merger, the case law is very clear that you can have multiple consequences of any criminal act. That's to be contemplated by any criminal act. Multiple consequences can flow from one thing. Multiple harms can flow from one thing. To parse it out to the point where you are saying one fracture, one bruise, one, name a specific injury. That's not what the law is intended to do. That's not what the merger case law says. In this case, what is the harm? It is the death. And in this case, the state has not been able to tie any of the separate injuries, the state has not been able to separate any injuries from death, particularly because of the cause of death.
The in count 4, that endangering count, is it, I'm just directed toward Ms. Naroda.
Okay.
Is your contention that that relates to the skeletal injuries?
Yes, that was set forth in the state supplemental bill of particulars.
Okay, and that was the predicate for the murder, right?
The same charge gives rise, yes, the predicate offense, but it,
So how do you differentiate those? If that injury was the cause of death, are you saying you can have that as a separate injury also, a separate offense also?
Judge, I believe that the state argued it that
I know what you argue, but I'm just, you're saying that it doesn't become murder unless the skeletal injuries under count 4 resulted in that caused the result being the death.
or the brain injury can be the subject of the predicate offense in count 1 felony murder,
Okay.
Judge. And that's what the bill of particulars discussed.
All right, anything else you want to add?
Just briefly, I think that's exactly what the case law says not to do, which is parse out the separate conduct. In count 4, I'm sorry, parse out separate potential consequences. In count 4, the state needs the abuse. That's the element of the offense. The abuse is what the state needs to prove that charge. The abuse encompasses any harm that would result from whatever the allegation of the conduct was. And in this case, the state was very clear, and the state has said throughout, it was not going to prove motive if it didn't have to, so it didn't. The state didn't prove conduct. The state said it didn't have to, and it wasn't going to, so they didn't. So the only real inquiry here is, can the state prove separate harm? And it's our position that you can't separate it from the fact that Zach died in this case. You can't separate any other injury, particularly, again, with that notion that these non-death counts are the predicate offenses. So we would ask that the court merge all counts into, if the state's electing to proceed under count 1, we would ask that the court merge all counts into count 1.
All right, pursuant to the revised code and the applicable case law, rough, I'm going to find that all counts 3, 4, and 5 merge into count 1, and we'll proceed on count 1. Mr. Rode, you want to proceed with, well, who?
Lauren.
Lauren, go ahead.
Yeah.
Thank you, Your Honor. This is a particularly difficult case that we're in front of you on today, and it's tough to find the right words to say. Billy entered a plea of not guilty. He maintains his innocence in this matter. We all sat through a lot of hearings. We sat through 2 weeks of trial. Billy has respected the court. He has done everything that the court has asked of him, and the court got to know him a little bit through his pre-sentence report and his time that he has spent here. One thing that was consistently clear throughout the testimony that we heard is that Billy loves Zach. Billy was proud to be a father. Billy was excited to be a father. He was ready to have a family with Katie. And this is not at all where Billy thought his life would go or how he expected his life to go. Unfortunately, we don't have the kind of clarity that I think everyone wants and expects in a case like this. It's not the kind of clarity that I think we'll ever be able to get. And that's unfortunate here. But Billy is before the court, prepared to accept any sentence that the court imposes, here knowing that there's a mandatory sentence of 15 to life. So we'd ask that the court sentence him to 15 to life on count 1 and merge the other counts. Thank you.
All right, Mr. Beasley, you have the right to say anything that you want at this point. Is there anything you wish me to consider?
Yes, Your Honor.
Yes.
I stand before you today to express to you all what an honor and wonderful opportunity it is to have been the father of such a handsome, beautiful little boy named Zach. And what a joy and happiness he bestowed into our lives, and how much a little man could change someone's life. Zach wasn't just my son, he was so much more. Ever since the day we figured out that Katie was pregnant, all I could think about was building a life that would just be everything a child would ever need or want. From deciding on the name to figure out deciding on a name to figuring out the theme of his room, everything I did was in preparation for Zach. I was so happy and excited to be a dad that nothing else mattered anymore. I got a better job, starting taking care of long unpaid debts, even thought about going to college and getting some sort of degree later on, so that Zach would have everything Zach needed to succeed and be happy. Then on the day that Zach was born, I looked into his grayish blue eyes and I fell in love. I knew I had a friend for life. Excuse me. All I could imagine was Zach, Katie, and I doing everything together, from fishing to camping and everything in between. Truly the happiest I've ever felt in my life. I was overflowing with bliss and joyous feelings. I was so proud to have our own family, to have been his father of such a wonderful little boy. I couldn't imagine life without him, and preparing said life, never looking back. What I was not preparing for is a day, one where instead of holding Zach, I would be wishing to hold him again. A day I hope no parent ever needs to experience. Zach was, and it still is, everything to me, and not a moment goes by that I'm not thinking of him or that he's not a part of me. Every thought, every decision, every breath I do is for him. For almost 2 years now I've been dealing and trying to cope with his loss, and each and every day the pain grows stronger and stronger, and I miss him more and more. Even though Zach is still with me and continues to give me strength to get through every day, there will always be a place in my heart, a place for Zach to always have a home. And even though the thoughts hurt and reminds me every day how much I miss Zach, they also remind me how much I love him. They remind me that Zach still and always will be here, continuing to guide me in making the right decisions, and that no matter what, we will always be best buds. Zach will always be my strength and will always give me courage, and for that, I will honor him for the rest of my days, in hopes that one day I will make him proud, just as he did and continues to do for me. I thank the court for giving me this opportunity to speak, and I thank my son, my best friend, my everything, Zach, for giving me the strength to stand up here today and speak to the court and everyone else and express myself, so everyone knows just how proud I am to have been and remain your dad. I love you, buddy. Thank you for everything.
Great, thank you. Anything else, Ms. Tuttle?
Your Honor, Billy's friend, Mr. Edward Cranick, would like to make a short statement on his behalf.
Okay. State your name, please, for the record.
My name is Edward Cranick.
Go ahead.
I'm here to speak on William Beasley's behalf. William is a dear friend of mine. I've known him for about 6 years now. He's a hard, working, loyal, lovable person. I believe William has been mixed up in a medical misfortune that no one could have predicted or could have known about. I truly believe William was only trying to be a loving, caring, happy first-time father. With that being said, I'd like to ask the court to be lenient with William. Thank you.
Thank you.
There's nothing further from the defense, Your Honor.
Thank you, Ms. Naroda.
Judge, the state would like to shift the focus to Zachary. This case was about his life and death, specifically 14 of his 32 days, Your Honor. I think when looking to sentence in this matter, the seriousness factors contained in 292912B are telling. When you look at 3 of those factors, the age of the victim, he was 32 days old when he left us. The serious physical harm he suffered, Judge, at the hand of his father, 5 hemorrhages, multiple rib fractures, 2 broken knees, a broken ankle, when he was only 6 pounds, Judge. Those profound and lethal injuries were inflicted by his own father, and the testimony demonstrated, Judge, that it was over time. It wasn't just one isolated incident. There were multiple modalities of injuries, as the doctors testified to in this case. And it was by choice. The defendant chose to set aside his duty of protection and care for his baby boy and acted on his own frustration or emotions and violently, forcefully abused his brand new baby boy. That resulted in his death. And the state would place on the record that we feel it's the most serious form of this offense, and ask that you impose the mandated statutory sentence of 15 to life.
Is there anything else you'd like to present?
Judge, I do believe there are 3 family members that wish to address the court. I'm not clear on what order, so I would...
All right,
turn to
whoever
the-
wants to speak, if you could just state your name for the record and then tell me whatever it is you want me to know.
My name is Susan Toth, and I am Katie's aunt. Her mother, Linda, was my best friend. Katie's mother died January 31st, 2020. Zachary was born on April 27th, 2020, and died on May 29th, 2020. He was only 32 days old. I was fortunate to be one of the people that actually got to meet Zachary, to hold him and to feed him. He was a beautiful, perfect baby. We have a large, close, extended family that spans 3 generations. After Caitlin's mother died unexpectedly, we embraced Katie and Billy because the impending birth of their baby was a cause for hope and celebration in a family still reeling from Katie's mother's death. When Zach died, I was one of a handful of people that reached out to Katie. Billy was very controlling and would not let Katie spend time alone with any of us. He isolated her from the rest of the family. If I tried to text her, she had to delete the texts immediately because he would get upset and angry if she was communicating with me. And Katie allowed that because she felt that after losing her mother and losing her baby within 3 months of each other, Billy was all she had left. She was very much in shock and could not comprehend that Billy was capable of inflicting harm on Zachary. In addition to losing Katie's mother and Zachary, he also felt as though we had lost Katie because Billy would not allow her to be with the rest of the family. Billy's dad, Bill Sr., was also a very good friend to our extended family and had been for many years before Katie and Billy met. That friendship has ended forever due to Billy's actions, and the family grieves the loss of that friendship as well. Until the trial, many of us have been unable to move forward. We have not been able to properly grieve either Linda's death or Zachary's death, and we are just now starting to do that. The whole dynamic of our family has changed as a result of Billy's actions. Some people blame Katie and cut off all contact with her. Some people see Katie for what she is, the mother of a murdered child. This tragedy has caused an irreparable rift in what used to be a beautiful, loving family. There are no winners here today. Zach is still gone. So many lives have been destroyed because of Billy's arrogance and his inability to control his anger. Thank you for allowing me to share my thoughts.
Thank you.
Hi, my name is Shannon Davis. Every morning I wake up and I think about Zach, how old he would be, what silly things he might be doing, and what memories we'd be making on our family vacations together. Then I remember the nightmare that we are living, the tremendous loss that we have had to deal with each and every day. My heart aches for Katie, but also for my whole family. Katie, Becky, and I are bonded forever over Zach's birth and death. They are like sisters to me, and their pain is my pain as well. I was ecstatic to be Zach's aunt and godmother. I couldn't wait to meet him, hold him, smell him, and kiss him. All of that was wiped away when I had to wait outside the Cleveland Clinic for a week straight because you couldn't even be there to support Katie or Zach. I had to fill in for you and be Katie's second set of ears and support during the worst days of her life. I had to listen to countless doctors describe Zach's horrendous injuries and the fact that he would have no quality of life ever. And each doctor took his or her turn describing the horrific facts. I listened to Katie's cries become louder and more intense as she squeezed my hand harder and harder in utter disbelief. I was absolutely disgusted and sick to my stomach as I heard each doctor describe the various broken bones and numerous brain bleeds that occurred over time under your care of Zach. How could anyone do this to an innocent, sweet, beautiful 6-pound baby? Immediately after hearing all the dreadful news during the meeting, we had to relay this terrible information again all over to you, and I think your response was, I think I should look into getting a lawyer. I have no words for that response. So back upstairs, we went to meet with the palliative care team to form an end-of-life plan for a 32-day-old baby. When we arrived in Zach's room, my life was forever changed. As we listened to the team of caring doctors and nurses, I just kept looking at Zach. How could this really be happening? He didn't deserve any of this. I watched Katie carefully take Zach in her arms. He had all these lines hooked up to him, giving him the medicine, trying to ease his pain and make him comfortable. Part of me wished she could just hold him like this forever, to keep him here. But the fact was Zach was hurting. The trauma and injuries were just too much for his little body. The damage was already done. Zach was swollen and tubes were sticking out all over his little body. No baby should ever have to look or feel like this, ever. As Katie held him in her arms, sang to him, read him books and kissed him, and rocked him, the reality came rushing over me. I had tried so hard to be strong for Zach and Katie, but I couldn't keep the tears in any longer. How could this be happening to sweet Zach and Katie? I had to witness the heart-wrenching decision to finally remove Zach from life support and wait, painstakingly wait, for him to gasp for his last breath. I don't wish that on anyone, ever. To watch a devoted mother and godmother witness this horrific moment is forever etched in my mind. I can never unsee this horrible experience that played out. It's a memory that I wish I could forget. One that I should never have had to witness. Watching the doctor pry Zach out of Katie's arms for what would be the last time was absolutely brutal. There Zach lay, perfectly swaddled and swollen, but finally at peace. The nurses asked us if we wanted to bathe him one last time, and this is something no mother should ever have to be asked of her 32-day-old baby. I quickly started to grab things from the room and try to pack up as quickly as possible because Katie was absolutely beside herself. Leaving Zach in that room, in that hospital, going home with an empty car seat with no Zach was gut-wrenching. Actually, it's indescribable. You wouldn't know, but we drove home barely speaking because we honestly were in such shock about what just had happened. The next few weeks were a blur. I was trying to support Katie, but she was still under your control. You continued to try and turn her against her family and alienate her from us because you knew what you had done and you needed Katie to be on your side. Then 2 months later, Katie found out she was pregnant. I wanted to be happy, but honestly, my concern for Katie and the babies just grew because after Zach's death, I learned about your temper and how you had been physical with Katie. Katie missed our family vacation because of you. Tension between Katie and the family grew because of you. The twins were born and I haven't been permitted to even meet them yet. Why? All because of you. I have missed out on over 365 days of their lives, the time that I will never get back. They have a whole huge Irish family waiting to love them up and help them cope with the trauma that you have already caused them. I have missed all their firsts because you were a coward. They don't know their grandfather, great aunts, uncles, cousins, godmothers, or any of this because of you, and I hope you can live with yourself and all the pain you have caused to so many people, especially your sons.
Thank you.
My name is Caitlin Hines. Today, Zach would have been 1 year, 9 months, and 28 days old. Instead, Zach is forever 32 days old. By now, Zach would have rolled over, said his first word, crawled, taken his first steps, learned how to feed himself, and would have learned how to throw a ball. He would look at you and me and call us Mommy and Daddy. Instead, Zach is 32 days old. Instead of a rowdy, healthy, beautiful little baby boy, he is ashes in a box inside another box in the shape of the Superman logo. The same box. If you look, I find myself trying to figure out how I can figure my body around just right in order to cuddle with Zachary at night. The box that should hold toys, but instead holds my young, dead son. Truthfully, Billy, I don't know what the hell to say to you. For almost 5 years, you called me the love of your life. You knew the thing I wanted most in life was to be a mom and raise amazing and kind children. You took Zach, and I quite possibly may lose custody of Alex and Nolan. I hope that resonates with you. You took the only thing that the love of your life ever wanted. You physically and emotionally abused me. I have pictures and proof of it in case you want to yet again play the victim. I don't deny that you had a rough childhood, but you chose to continue the cycle of abuse. You chose that consciously over 5 times, as you told the detectives. 5 times you looked at our beautiful, healthy, innocent baby boy who looked exactly like you and chose your ignorance, arrogance, and narcissism over Zachary's life. You have disappointed so many people, including me. You have affected so many more people than you can comprehend. More importantly, you let Zachary down. I used to think he looked at you like you were his hero. I now wonder if he was looking at you and begging why you were so mad, asking with his eyes, "Daddy, why are you hurting me?" You are solely responsible for Zachary's death, and you knew it from the very beginning. You lied to me for over a year. You stole such a bright light from this often dark world. You, William Lee Beasley, murdered Zachary William Beasley. You murdered your son.
Thank you. Anything for Ms. Naroda?
Nothing further, Judge.
All right, I've reviewed the pre-sentence report. I've also reviewed letters submitted by the state, including the 3 individuals who spoke. I received and reviewed letters submitted on behalf of Mr. Beasley. I've listened to counsel, listened to Mr. Beasley, listened to the other folks who have talked here today. And I've considered all the applicable statutes, most notably 29.02B1, which is the mandatory sentence in this case. So this, I think there were 29 witnesses that testified in this trial. Most of them were, or at least half of them were medical witnesses with very stark differences as to what caused the injuries and ultimately the death of Zachary. Two polar opposite theories of what occurred, and the jury made their finding after listening to all that evidence. So clearly, as I sat here and listened and considered all the evidence, it wasn't a medical misfortune that caused these injuries and caused his death. As I recall it, serious brain injuries, but 29 fractures, including the legs, a lot of ribs, 29. That doesn't happen by accident. That happens because you took some action that caused those injuries. You described that somewhat in your interview with Detective Kreisha and Detective Knack. How you handled Billy, and that in and of itself went a long way, I believe, toward the jury's determination of what occurred here. Now, it's my belief, after having this case for whatever it's 9 months and having several hearings and sitting through the trial, that you didn't set out to purposely cause Zach's death. And the jury's finding reflects that, based on their not guilty verdict on one of the murders. But clearly, your actions that you took caused these injuries and caused his death. There's no question about that. And you have to account for that. And now, whether it happened out of pure anger or pure frustration or a combination of those things or carelessness, it really doesn't matter, because the 29 fractures are what in fact occurred, and the brain injuries are what in fact occurred as a result of what you did. And I'll tell you, one of the most haunting exhibits in this case was a picture side by side of Zach on that screen of, I believe the last picture was on 5/21, and the other one was a couple weeks before that. And what a stark difference in the appearances. It struck me that 5/21 picture, he looked like a little old man. So you could see in that short time that ensued that for whatever reason, he took a beating that caused the 29 fractures and those brain injuries. And that's what the jury found. That's, I think, clear from the evidence. So here we are. Nothing can change it. Can't reverse course. This is where we are. And so your sentence is going to reflect the reality of what happened during the course of those 25 days, really. He was in the hospital the last 7 days. So after consideration of all the applicable factors and the evidence in this case, pursuant to Revised Code 2929.02B1, I'm going to sentence you on count 1, the only count in this case, since the other counts merge, of a sentence of 15 years to life in prison. There were no restitution claims, Ms. Naroda? I'm not aware of any.
Not to my knowledge, no.
Okay. So that is the mandatory sentence in this case. That's your sentence. When you are released from prison, you'll be on post-release control for 5 years. I believe that's applicable. Is it not? It's applicable in every...
I don't believe it's
not, there's no post-release control on this?
on murder. No, I don't believe so,
Okay.
Judge.
All right.
It's a parole offense.
Okay. All right, so you'll be subject to parole when you're released. You have a right to appeal your conviction and your sentence to the 11th District Court of Appeals. You have a right to have a lawyer represent you in the appeal. I don't know the position of the public defender in this case.
Your Honor, we would request that outside counsel be appointed for the purposes of appeal due to the complicated nature of this case and the volume of evidence that we have. We would specifically request that the Ohio Public Defender's Office be appointed as counsel. We've reached out to their appellate division, and they are able and willing to take Billy's case.
Are they going to file the notice of appeal, or are you guys going to file
We
it?
can coordinate with them on that, Your Honor. If
Okay.
we file it, we'll file it and then ask through an entry that they be appointed if the court's willing to do that. Otherwise, we can just ask that they file a motion for an appointment, and then they can file the notice of appeal thereafter.
All right, so I'll appoint the Ohio Public Defender to represent you on the appeal. If you will coordinate with them on the filing, you have a right to have a timely notice of appeal filed in this case, so your lawyers and the Ohio Public Defender will coordinate on that. You have a right to all the transcripts in this hearing, and if you're indigent, you can't afford them, they'll be provided free of charge to you. Is there anything further from the state?
If I could have a moment, Judge? Nothing from the state, Judge.
Anything from the defendant?
No, thank you, Your Honor.
All right, we're adjourned.
All right.